On November 11, 2025, something truly significant happened. The regional court in Munich delivered a ruling that really represents a major turning point for regulating generative AI in Europe. The case, GEMA versus OpenAI, has fundamentally reshaped the legal and, frankly, the operational landscape for any AI developer working on the continent.
To really get a handle on the full impact here, we're going to explore 6 key areas. We'll kick things off with the Munich precedent itself, and then we'll dive deep into how the court redefined what an AI copy even is. After that, we'll look at why OpenAI's defenses just didn't hold up, see how this ruling creates a kind of fractured legal landscape, and then unpack the economic fallout, what I'm calling the end of free data, before we look ahead to the future of AI in this brand new environment.
So at its very core, this case was a major confrontation. It pitted two forces against each other that represent opposite ends of the digital rights debate. You have the established power of traditional copyright management versus the disruptive force of generative AI.
On one side, you've got the plaintiff, GEMA. They're Germany's hugely influential collective rights society. Now, they represent over 95,000 composers, lyricists, and music publishers, so their entire reason for being is to make sure creators get paid when their work is used. And on the other side, the defendant, OpenAI, the company behind ChatGPT, whose entire business model, let's be honest, depends on swallowing up enormous amounts of data from the open web to train its models. The case itself was very strategically focused. It honed in on a narrow but incredibly powerful set of facts: ChatGPT's ability to reproduce, almost word for word, the lyrics from 9 highly recognizable German songs. And these weren't some obscure tracks. We're talking cultural staples from artists like Herbert Grönemeyer and Helene Fischer. GEMA argued this proved 2 key things. First, that an illegal copy was made when the model was being trained, and second, that an illegal communication to the public happened whenever the model spit out those lyrics for a user.
And this brings us to what is probably the most intellectually significant part of the entire ruling. This is where the court went way beyond just the surface-level function of a chatbot to actually redefine what a copy really means in the age of artificial intelligence.
You see, OpenAI's main technical argument was that its models don't actually store data. They said they just learn statistical patterns and correlations, kind of like a human student does. The court firmly rejected that idea. Instead, it embraced a technical concept called memorization, finding that when a model can hold on to and then reproduce specific training data, it has, in a legal sense, made a reproduction of that work and fixed it right there within its own parameters. To make this pretty abstract concept more tangible, the court used a really striking analogy. It compared the AI model's parameters, or its weights, to a lossy compression format, like an MP3 file. Think about it. An MP3 doesn't contain the exact original sound wave. It's a compressed mathematical representation that lets your device reconstruct the song. The court reasoned that, in the same way, if an AI's weights allow for the reconstruction of copyrighted lyrics, then those weights themselves are a compressed and therefore infringing copy.
The court essentially applied a kind of the thing speaks for itself logic. It just dismissed the notion that generating complex, specific lyrics could be some random statistical accident. Instead, it saw a direct causal chain. The lyrics were used in the training data, they were preserved inside the model, and then they were reproduced as output. The output itself was all the proof they needed.
Now, OpenAI didn't just rely on its technical arguments. It also brought up several key legal defenses that are based on European copyright law. But the court systematically dismantled every single one of them.
Their primary defense rested on the EU's exception for text and data mining, or TDM. This is what allows for the automated analysis of data to find patterns and trends. The court actually agreed that AI training is a form of TDM, but, and this is a critical but, it drew a very important line. The exception is meant for analysis, not for memorizing and then reproducing the creative expression of a work. The court found that goes way beyond what the law ever intended. Next up, OpenAI tried to claim the broader TDM exception for scientific research. The court dismissed this argument almost immediately. Look, while OpenAI might have non-profit roots, ChatGPT is clearly a commercial product. The court pointed out that for this defense to even apply, the company would have to prove it operates with absolutely no commercial goal, which is, well, plainly not the case. And finally, in a classic move you see from platform companies, OpenAI tried to shift the responsibility onto the user. They argued that the infringement only happens when a user prompts the model to generate the lyrics. The court wasn't having it. It rejected this, calling the user's prompt just a trigger.
The real responsibility, it said, lies with the company that chose the training data, built the system, and made the illegally stored content available in the first place. And that is OpenAI.
This ruling didn't happen in a legal vacuum, of course. To really understand its full importance, we have to put it in context with what's happening elsewhere, especially in the United Kingdom, where a court reached a very different conclusion.
So, in the UK case of Getty Images versus Stability AI, the High Court came to a completely different conclusion. It found that model weights were not infringing copies and that it didn't even have jurisdiction because all the training happened on servers outside the UK. The Munich court took the exact opposite stance on both points, creating a really clear divide. The German ruling prioritizes protecting rights holders, while the UK approach gives more protection to AI developers. This is creating a really complex legal patchwork across Europe.
So, what are the practical consequences of all this? For the AI industry, the economic and operational shockwaves are, well, they're both immediate and profound. This signals the end of an entire era.
For years, that prevailing Silicon Valley mindset has been to move fast, break things, and then ask for permission later. This ruling sends an unmistakable message that, at least in Europe, that approach to getting data is just not going to fly anymore. The whole era of treating the internet like a free, all-you-can-eat buffet of training data is, for all intents and purposes, over.
This creates some major new burdens for AI companies. First, there's the licensing imperative. They have to actively negotiate and pay for the data they use now. Second, there's a huge technical challenge. How do you remove or unlearn infringing data from models that were never designed for that kind of selective deletion? And third, it creates a strategic dilemma. Do you pay to license content, build entirely separate EU-compliant models, or just block European users from your services altogether?
So where do we go from here? This ruling sets up a new reality. In this post-Munich world, both rights holders and AI developers are going to have to adopt new strategies to navigate the path forward.
For rights holders, the strategy is pretty clear. Formalize their refusal to allow data scraping, actively monitor AI outputs for infringement to build up evidence, and use the collective power of groups like GEMA to negotiate big, sector-wide licensing deals. For AI developers, the path is all about compliance. This means putting in aggressive output filters, auditing all their training data, and building the cost of licensing right into their core business models. This new reality might actually favor the huge, well-funded companies that can afford these massive licensing deals, which could create some real challenges for smaller startups and open-source projects. Ultimately, the Munich court has forced a reckoning. It stripped away all the complex technical and legal arguments to ask a really simple economic question. It has affirmed that in Europe, the raw material of human creativity has a price. The real question now is whether the AI industry is willing and able to pay it. The answer to that is going to define the future of innovation for the next decade.